basically, we just have a lot of questions about care court, as you know, and I'll start off by talking about who exactly it's for. Newsom has framed care court in press conferences as well as meetings with advocates as kind of this end-all be-all to homelessness. Meanwhile, you said it'll get 5 to 12,000 across the state off the streets. So that's pretty different messaging. So I'm curious, one, what's the answer? How many will be served and who will be served? Because while this is being, initially framed as a homeless bill, when you actually really read the bill that just came out and the criteria, it's basically anyone over 18 with psychosis, which is extremely broad. So we're hoping to get some answers from you.
Yeah, so I like to say homelessness is a challenge for California with many faces. And one of the most important and tragic faces are those with serious behavioral health conditions who are living on our streets and under bridges. And some of those individuals, we estimate roughly 7 to 12,000 individuals across the state who have schizophrenia, other psychotic disorders, schizoaffective disorders, so specific clinical criteria verified and diagnosed by clinicians doing evaluations may, in the course of their evaluations, find that care court, a program that's designed to serve this target population, is the appropriate route. So indeed, it's not the entirety of those experiencing homelessness, but I would say it's one of the most overlooked populations that often doesn't get served and needs to be, because tragically they spend years and years on the streets and often face extremely bad outcomes as a result.
Gotcha. Cool. And I wanted to also follow up on, do you have to have a diagnosis of schizophrenia spectrum or another diagnosis of a psychotic disorder, or is it just psychosis? Because, a lot of people living on the streets maybe don't have that level of, mental health care or medical care that they'd even have a diagnosis. So would you have to have one in order to be put into care court, or would it be something where you go into care court and then a diagnosis is made?
It could be the second, Andie, but we know many individuals may already carry a diagnosis from, recent encounter with 5150 hold, or while they were hospitalized. So that might be a diagnosis we can quickly uncover and use as part of the care court process, or based on symptoms, based on a set of conditions, they come into the care court process, get an evaluation, and then indeed get a diagnosis according to the clinical criteria.
Okay, because I think when you read the bill too, it's kind of unclear on that side. So it's, you come in and you can get a diagnosis. So basically it's anyone over age 18 that kind of is showing those symptoms.
Yeah, and so there's a pretty prescribed petition process, both who can be a petitioner and then what the process is. It's meant to have a signed affidavit by a clinician who verifies individuals meet the clinical criteria. So that would require that evaluation and a set of understandings, just like we do for any condition, diabetes, heart disease. Psychiatrists, behavioral health professionals can make that diagnosis through the evaluation process.
Okay, gotcha. And we've spoken with many who believe care court infringes upon human liberties, especially regarding the drug treatment portion of it. So my question to you, is court mandated treatment a violation of civil rights?
Well, what I like to focus on when talking about care court is really the process is about accountability on a number of levels. And I start by focusing on government accountability, making sure that we, as stewards of the resources and with the obligation to serve our most overlooked, our most vulnerable citizens across our state, that part of the care court process, and first and foremost, is to ensure that individuals who have these conditions living in encampments, on the streets, under bridges, but maybe they're coming out of an institution, they're living with a family member, and they need these same sorts of services, and they're just not getting them, that we have an obligation and need to make that commitment to individuals to do that. Indeed, that through the course of that process, things like medications may be prescribed, maybe even may be required in order to stay sort of part of the care court process and following your plan. And if it does not occur, right, if people don't stick with the plan, then they certainly wouldn't remain in care court, and other systems may find themselves as part of other systems, whether that's the conservatorship process is one that people often reference quite a bit. So, certainly there's a component here, and I'd say the leading edge of the program is making sure that the resources that Californians put towards these important programs actually touch the lives of this very vulnerable group of individuals. Individuals that, Andie, most of us know someone. Most of us have encountered individuals and know them as family members, as friends, friends with family members who really do need this sort of support and help. And we have an obligation to serve them to the best of our capabilities.
Gotcha. And so next question for you, I've covered probate court intensively. So I know from that one, but as well as our civil and criminal courts, all these court systems are inundated. Why are we creating an entirely new court system that would require multiple court hearings? I think it's 7 from what the bill looks like for someone to get into the care court system, and as well as, public defender and supporter roles. The supporter is a completely new role. Why are we creating all this when our court systems are already overwhelmed? And how are public defenders realistically going to be able to handle even more court hearings when they can't currently take on new cases?
Yeah, it's a really important question. I think we look to the courts to do a number of different things across society, across behavioral health, across the criminal courts. So we are this will require additional investment in the courts. This will require us to build up infrastructure. The new supporter role that you mentioned is meant to be a really supportive decision maker component of this, rather than that substitute decision-making process that we find in whether it's the criminal court or the conservatorship process. So it is a new approach, still using the court. It's going to take some investment in all of the components you mentioned. And ultimately, the plan, the approach is going to require us all to really step up and focus on this population in a way, frankly, we just haven't over the last many years.
Gotcha. And going off of that, you are saying it's a new approach, but we do have Laura's Law and the LPS conservatorship system to address very similar things that care court is trying to do. Why are we using billions of dollars to create something new when the systems we have in place are already broken? Why are we not fixing those?
Well, I think there's a lot of approaches to how we think about solutions to important problems in California. Sometimes we approach it by fixing existing systems. And in this case, we've chosen to go further upstream, not wait until people are in the position to be referred either into the LPS conservator process, the felony incompetent to stand trial process that we find many of the same individuals in, or even the Laura's Law process. So going with a very different approach, not replacing or even fixing those existing systems, but creating another more upstream tool in the toolkit so that we can serve individuals even earlier. So that's our hope. And just as you noted, the systems are inundated, but they're often inundated further downstream. And if we can move some of those engagements and encounters a little bit more upstream, we think that not only can we serve people better, but we'll find that we're able to serve more people and sooner as well.
So are you kind of saying that, the solution to court systems being inundated is to put more money towards it, and that will fix it by giving them more resources?
No, I think that part of, certainly as you build up more processes investments in those processes are often needed or required. And in this case, we'll be giving a new function to the courts, asking the courts to participate in something new, as well as the supporter role and the legal representation. So they will take some resources to build up, but the hope is through this process, right, that we will be able to better serve people who otherwise languish on the streets and encampments, undertreated from their behavioral health conditions that we've just talked through, and often are sicker and cycle out of very expensive and inefficient systems a little bit further downstream. So the hope is through these investments in the care court process, we're actually able to do what we're not doing today, which is serve individuals successfully in a way that they have a hand in creating the plan, in creating the housing plan, their treatment plan, choosing who might be helping serve them as part of their clinical team, so that we have that important buy-in and engagement process that we know is so essential to making plans actually meaningful for people's lives.
Gotcha. And I know I've already touched on this, but I got to kind of hold you to the public defender side, because, here in Sacramento, we just had this shooting that, was national news. The first suspect that was arrested, he couldn't be represented by a public defender because that office was so inundated, like the biggest shooting that's happened in, our state's history for a while, couldn't even have our, court system behind it because they're so busy. I'm just very curious how this will work with public defenders specifically.
Yeah, I think these are details that, through the coming weeks, we'll be working on, trying to build up exactly what the investments are going to require and how we make sure that we put the resources, both fiscal resources, but also the human resources to serve this group of individuals. And we know that many of the individuals that we're speaking about are suffering significantly on the streets, and then finding themselves into court processes already and inundating those systems as it is. So the hope is that for many individuals, we're able to sort of restructure some of those other processes to make sure that that strong representation on all sides, but really that clinical piece as well, is made available to individuals earlier.
Okay, I'll definitely be interested to see as more information comes out about that. One of the big parts of care court is that it would provide a housing plan. You guys put that in the framework, but specifically in chapter 5 of the care plan in section 5982, it says, I'm going to read this directly to you. This section does not allow the court to order housing or require the county to provide housing. So basically, to me, that reads housing is not absolutely required. So, homeless advocates, as well as Governor Newsom himself, has said housing is what it takes truly to solve homelessness. Without housing being absolutely required by care court, could someone basically go through the entire care court system and end up back on the street?
Well, certainly the housing plan is meant to be a individualized plan created for a person based on their desires, wishes, where their supports are. And so creating the plan is a requirement. The state has, over the past 2 to 3 budget cycles, including proposed now $1.5 billion in the governor's budget from January of this year, that if passed by the legislature, would be made available for exactly participants in the care court process, as well as a myriad of other investments that have been made in the behavioral health continuum and infrastructure in our communities to support individuals who need housing that's enriched with clinical services, as well as another $12 to $14 billion in investments in housing. So between the plan and the expectation of the plan and the resources that both counties and cities have been provided by the state, we believe that those two things together are going to create housing placements for this population in care court.
Great. And it's my understanding your initial goal with Care Court was to increase state hospital beds by shortening the beds needed for incompetent to stand trial defendants. But does this proposal really solve that problem, especially because the bills AB 280, 2830 and SB 1338 for this, they only allow misdemeanor IST defendants to be referred to Care Court as opposed to felony defendants?
Yeah, this is not primarily a felony incompetent to stand trial solution. Frankly, what we are trying to do is before an arrest, get individuals the care and service that they need. After an arrest happens, and if it's a felony arrest and a felony charge, then individuals may go through the incompetent to stand trial process, which has a whole different set of resources and rules of the road, if you will. So this is not meant to really be something for felony IST individuals at the moment. The misdemeanor ISTs, the incompetent to stand trial on the misdemeanor side, no longer, because of legislation from last year, can be held in jail. So as counties are thinking through how they address the needs of misdemeanor incompetent to stand trial defendants, Care Court may become a very important, both strategic and helpful resource to make sure that comprehensive care plans are put together for those populations as well. So we focus on the misdemeanor because of the unique nature here in California, but what we're hoping to avoid are people going into a felony IST set of proceedings.
Gotcha. Two more questions specifically about that. I know that has been something in your career you focused on, very in the weeds there specifically with, the felony misdemeanor, but overall, Care Court is a big step in that direction. Are you happy with how the bill turned out?
Yeah, I think that like everything, the engagement process, the hearing process, allowing the public to testify and give ongoing feedback, and the collaborative work with the legislature is going to continue to improve the concept and allow California to do something that I think not only have few, if any other state done before, but really represents the values of California and really promotes the California way, which I think is led with compassion and commitment to those who are often most overlooked and most underserved. So I'm pleased that we're heading in the direction that this population may get the sort of attention and support that I know many of us in behavioral health, in public health, in health services care deeply to see them receive.
Gotcha. And what happens if an individual is incompetent to stand trial, but then doesn't comply with Care Court? Because it's my understanding you can't refer them back to criminal court because they've been deemed incompetent, right?
Well, there's when you're incompetent to stand trial, it's really suspension during that time where a doubt is declared. Your criminal court proceedings are suspended until you can be restored to competency. And if you are restored to competency, then you would return to your criminal proceedings. If it is the case that somebody referred to Care Court does not either follow through with the whole plan, they are not then restored, then they would be subject to the normal misdemeanor or, if it were the case of the felony, those normal timelines and procedures. So indeed, somebody could be referred back into the criminal proceedings and the whole IST process, depending on the sort of circumstances of that individual's case.
Gotcha. And I've covered conservatorships so much. Obviously, I'm also seeing, the worst side of conservatorships where there's a lot of conservatorships that do help people. But, with this, I can't help but compare the two a little bit because they are pretty similar, especially the supporter and conservator role. I'm just interested, do you think that this bill could, be subject to abuse?
Well, we are putting, with the help of a lot of different stakeholders, really trying to build safeguards into a number of the steps in the court process and the clinical assessments and the petition process, really trying to distinguish from the conservatorship systems and approaches, which depend on substitute decision-making, actually bringing in someone to make decisions on behalf of an individual. The goal in care court is to, as quickly as possible, through the use of supporter, through the use of stabilization medications, to really help support someone to make the decisions for their own plan, for their own living situation. So I would say it is materially different than the conservatorship pathway in that the focus is not on substitute decision-making, but rather supportive, collaborative decision-making that really reflects the individual's wishes and desires as much as possible.
Gotcha. And, what I noticed was there's no language in the bill that would make a supporter different than the same person who filed the petition. Do you think that could be a conflict of interest? And furthermore, yeah, I'll just leave it at that. Do you think that that could be a conflict of interest?
Certainly could be. And I think these are the kind of issues that through the ongoing conversation in legislative hearings and in stakeholder engagement, we're going to have a chance to dig into and really do California's best job at getting this right. What we want is a program and a system that is not just sustainable, not just something that we can move forward through the legislative process, but something that is really going to help individuals who are really suffering in pretty difficult situations across our state, where we don't quite yet have the answer on how best to serve them. And we know that these programs can work, that they exist even within our state. And through the care court process, we believe that we can make that lasting commitment to serve individuals safely, successfully, and compassionately, the way we expect to do most everything here in our state.
Gotcha. And kind of last question for you from me. In the beginning of the bill, I thought it was interesting because you guys named that these types of mental health issues often lead to a number of things, including being homeless, conservatorship, but in a way, care court also could be seen as a pipeline into conservatorship if you don't abide by it. Kind of what's your response there to people who are concerned that this could, lead to conservatorship?
Well, I think first off, we need to recognize that there's going to be a significant number of individuals, we certainly hope and expect, that are going to be referred into the care court system, desperately need the services that they have not received. And through this system, they're going to receive housing, they're going to receive thoughtful, supportive, individually tailored treatment and medications, and begin to stabilize. So we believe that the vast number of individuals who are referred into, petitioned into the care court process are going to have successful endpoints. We talk about graduations out of the process, being stably in community. Certainly, like we see in all programs, especially programs for individuals with complex behavioral health, substance use, as well as medical diagnoses, that they're not perfect. They don't serve everyone with the same outcome. And so there will be some, just like we see in other programs, where individuals would need something else. And then we have these other tools, as we talked about earlier, in our toolbox, including the conservatorship pathway and some of the other systems that we already have here in California. So we recognize that this isn't going to turn into a successful outcome for every individual, but we're certainly trying to build it so that we have the most success for the most people across the most parts of California.
Great. I think that was it for my questions. I appreciate you answering them in such a short amount of time, such complex questions. Was there anything I missed that you really wanted to address?
No, I think you asked just about everything. I think the one question at a very high level, right? Why are we really promoting or supporting a program like Care Court, and you probably covered this earlier or talked to others, we feel strongly that the group of Californians who suffer from these clinical conditions, who end up living in the conditions often on the streets, that we need to do more for them. And what we're doing now just isn't working. And that's manifest in the day-to-day lives of hundreds of thousands, millions of Californians who either know someone suffering on the streets or, encounter them on their drive to work or walk to school and ask why we can't do more. And Care Court is a real attempt at doing more for that population. So I hope that as we continue these conversations about how to craft the most compassionate, thoughtful, successful program that keeps the individual in the center, that we keep that really important challenge for California in mind.
Great, perfect. Well, thank you for your time. I really appreciate it.
Thank you and good luck.